Thanks for joining us. I'm Pam Metzger. I'm the director of the Deason Criminal Justice Reform Center at the SMU Dedman School of Law, and I'm so pleased to welcome you today to our webinar. This is part of our STAR Criminal Justice series, which focuses on the operation of small, tribal, and rural criminal legal systems. Today's program focuses specifically on small and rural systems, looking at the conflicts of interest that arise for rural practitioners. And with that, I'm going to hand it over to our panel moderator, Professor Lauren Sudeall, who is at Georgia State University, where she directs the Center for Access to Justice. Lauren.
Thank you, Pam. Thank you for having me. And it's great to at least see everyone in some theoretical sense virtually. Thank you for joining us. And I'm really excited about this panel. We were talking earlier about the fact that this is such an important issue and yet has received surprisingly little attention. So I'm glad to be able to help shine a light on it today. We have a really great panel of people who have a lot of expertise in this area. And before I introduce them briefly, just a few words to expand on what Pam said about the topic. As many of you know, I don't know the full makeup of our audience, but I suspect a lot of you are engaged in rural practice yourselves or live in rural areas. Perhaps you engage in criminal practice more generally and are curious about how these issues play out in such areas. But undoubtedly, as a lot of you are familiar with, there are a lot of characteristics unique to small and rural areas that can create unique challenges, particularly of the ethical variety, including having fewer lawyers. Myself and others have written about these areas as legal deserts because there are so few lawyers. Further distances, everything is spread out, courts, clients, lawyers, just areas altogether, and yet the space between the parties involved can be smaller. Right? A lot of parties may be more familiar with one another, individual actors may play multiple roles, the idea that you have had contact with other actors in the system is greater. And so a lot of those issues, as we'll discuss today, create challenges that then create tension with the ethical rules. So we will be talking with our panel about how they have experienced those issues, how they've responded to those issues, and also how they try to manage those tensions themselves and what recommendations they may have for how all of us can sort of try to move this area forward. One logistical note, if you do have questions that come up for our panel or that you'd like us to throw into the discussion, please post those in the Q&A and we will try to address some of those in real time if we can, but if not, we will also have a section at the end that we dedicate to Q&A. So with that, as I mentioned, let me introduce our panel. We have John Fossum, who's the elected county attorney for Rice County, Minnesota. Before assuming that position, Mr. Fossum was engaged in private practice and also worked as a public defender. He has over 27 years of experience in criminal appellate, and civil litigation. Thank you for joining us, John. We also have Mr. Travis Finck, who's the executive director of the North Dakota Commission on Legal Counsel for Indigents, which is the statewide agency responsible for the delivery of indigent defense services in North Dakota. He has worked primarily in the area of criminal defense and has devoted most of his professional career to that area. And last but not least, she probably does not need introduction in this audience, but we have Professor Pam Metzger, who is professor and director of the Deason Center. Before joining SMU, she was at Tulane, but as many of you know, she is a nationally recognized Sixth Amendment and ethics scholar whose work combines theory and practice to improve criminal justice. So again, thank you for joining us. And to get into the substance of our discussion, the first thing I'll ask our panel to do is just provide a brief anecdote or two that for our audience can sort of demonstrate some of what I'm talking about, right? Maybe how some of the dynamics of rural criminal practice create some of these tricky situations that can introduce tension with the ethical rules. So Travis, maybe we'll start with you and we can all just chime in.
Thank you, Professor, and thank you everyone for being here today. Some of the unique circumstances that we see, at least in North Dakota, is because of the lack of lawyers that we have, or the lack of lawyers willing to practice in the field of criminal law, whether as prosecutors or defense attorneys. A lot of times we have people who wear multiple hats. So we might have someone who serves as a contract public defender for us and takes cases for us on a conflict basis, who also might serve as a small town county prosecutor in the next county over. So that causes some problems. And then just additionally, anytime we have any sort of situations with mass arrests, we run into issues just because of the limited number of attorneys that we have at our disposal to take cases, such as when North Dakota was the site of a pipeline protest. back in 2015 and 2016 regarding the Dakota access pipeline, where there were some events where there was multiple people, sometimes upwards of 50, 60 people arrested in the same event, and trying to find attorneys that don't have conflicts to represent all those people. So those are the types of issues that we're seeing in rural North Dakota anyways.
Thanks, John. Do you want to? Oh, go ahead.
Sure. I'm sorry. I wasn't not trying to jump on it, anything here, but I was trying to think about this. I got, of course, 27 years of anecdotes to come up with, and trying to pick a few. But I think that one of the issues we talked about in one of the early meetings is what about where there is a limited number of defense attorneys, and there is a person who is a snitch in some cases and a defendant in other cases, and how often one of those issues that we certainly saw a lot when I was a public defender is we'd find out at the last minute who was being used as an informant, and suddenly the lawyer who's on the case has to get off and they have to find someone else to handle that case because they are representing that person in another file. And one of the things I was thinking about this morning as I came in, because we have an appellate case on this, and because I'm advertising for positions at the moment, is that we had there was a case in another county where there was a lawyer who was trying a case involving a criminal sexual conduct case, and 4 days before the trial applied for a job with the public defender's office. And the client found out about this shortly after the trial, after he was convicted, and asserted that as part of the claim of ineffective assistance of counsel. And in reading, and I went back and reread that appellate decision this morning, because it's one of the things that I often think about when we're looking at applications. If we have people who are defense counsel, and some of them have cases with our office, is this something that we need to deal with? And the court determined he did a good job with the trial. The client was convicted, but that there was no indication that his advocacy was other than zealous, that he did a good job, and he did get the job at the county attorney's office. But at least one of the judges in his concurring opinion said, I agree in the result, but I think that the lawyer had a duty to notify his client at the time he applied for the job, so that the client could say, I want a different lawyer for trial because this lawyer is applying for a job to the county attorney's office, and therefore it can't be as loyal and zealous to me as he should be. So I think that's one of the things I often think about when we're reviewing applications and dealing with people that we deal with in court.
So Lauren, I think that leaves me. Would you like me to talk about Antidote, or you want me to jump into some rules, which is something we had talked about?
Well, if you want to share an anecdote, we can do that and then transition.
Okay. So actually my kind of a passion for this topic began with one of these crises, much in the kind of situation John was just describing. Small town in Louisiana where the sheriff made 19 new criminal cases using a single star witness who gathered up 19 of her formerly closest family and friends, got them all arrested. And there was a 3-lawyer public defender office in that parish, which is the county governmental unit in Louisiana. All of them had represented the sheriff's key witness. Therefore, none of them could represent any of the defendants who were incarcerated. And there was a really, I think, pressing problematic question about who could even explain to these folks their right to waive their right to conflict-free counsel, since the only lawyers that were available to explain to them and advise them about whether they wanted to waive the right to conflict-free counsel were in fact the lawyers who were conflicted. And it created an enormous logjam. And one of the issues that emerged, for me at least in thinking about that, was recognizing that the systems with which we organize public defender offices, and I suspect as well prosecutor offices too, although to a lesser extent, since they tend to be more localized, but they have a really profound impact on how we understand conflicts. And in fact, one of the key conversations that we have on the public defender side is who is and is not a government employee who is and is not the member of the same firm, so that conflicts are imputed. And those kinds of issues, along with most of the other conflict rules, I think, were built with a lot of goals in mind, but providing adequate representation to defendants and appropriate state advocacy for county and district attorneys. I don't think that was one of them.
So we thought, since you've raised the rules, we thought it might be helpful. I'm sure the audience already sees the issues that are arising from the situations people have described, but we thought it would be helpful for you, Pam, to just provide a brief, sort of really high level overview of the rules to provide us with sort of the other side to see what the tension is here.
Sure. So, if we step all the way back, I think there are, two clumps of rules that we're involved with. One is the basic obligation of competence, which is the conflict piece that arises primarily in defender offices where you have too many cases. And we certainly know that that can be a problem for rural lawyers in places where there's lawyer scarcity. But the bigger set of conflicts issues that we're focused on today are the rules articulated in the ABA model rules 1.7, 1.8, 1.9, 1.10, 1.11. And without kind of nerding out too much, let me try and highlight what I think are the features of those rules in the model rules, in the ABA formulation, that set the stage for these problems. And I recognize that we have folks on this webinar from lots and lots of different states, and your state's version of the rule may not be the same as the ABA version. And that's part of the reason there perhaps isn't a great doctrine that's been developed about this. The fundamental starting place in all of these rules is the notion that the drafters are trying to balance the core values of loyalty to client, of confidentiality of information, not just privileged information, right, but confidential attorney communications with their clients, confidential client communications with lawyers, information learned in the course of representation. And they're trying to honor that core set of lawyer values, which are at the heart of what lawyers provide to their clients, whether their client is the state or their client is an individual who's charged with a crime, against the reality that lawyers are not fixed creatures, right? Lawyers move from job to job, they move from place to place, and shockingly enough, they have personal lives. So they may have personal interests and personal conflicts that arise. And if you see the rules in that light, 1.7, which deals with concurrent conflicts, is really an effort to help lawyers assess when a conflict exists, right? To look at their own experience with a particular situation. 1.8, on the other hand, is really a hodgepodge of rules, special problems. We can come back to those. 1.9, which is the past conflict rules, really doubles down on this idea that we have core expectations of what clients deserve from their lawyers, and that those obligations don't end when the representation ends. When you move forward into the rules, into 1.10, and particularly 1.11, 1.10 is a kind of a broad imputation rule. 1.11 is the special rule about conflicts of interest for former and current government employees. What those two rules are doing, 1.10 and 1.11, is they are dealing with the accommodations that are necessary to recognize that lawyers do change jobs. Their positions change, they move through the world, and that if we were to hold to this idea that loyalty and confidentiality is an immutable, unchangeable priority, no one could ever change their law practice. Right? No one could ever move or ever grow, particularly in a smaller community. So the idea was to build a compromise. And in general, the compromise is that if there is a conflict that involves a lawyer essentially litigating against themselves, it's not waivable, past, future, present. If it is a conflict that the lawyer believes they can handle and the client consents to, you can get a waiver. If you are in a situation where the lawyer is moving and has changed to a new practice, in many, many places, you accommodate that by what we call screening, right? You wall off that one lawyer, you make sure the client knows, and the rest of the firm or the rest of the practice goes about business. And finally, if you're a government lawyer, where arguably you acquire all of the conflicts of the government, which would make it impossible almost for you to move, we have a special set of rules that are designed to allow you to move through the world that focus on what you yourself actually know as a lawyer and then screen you accordingly. That's the premise. The problem is that those rules only work when there are alternatives to the conflicts. So in other words, if conflicts are not waived or if conflicts are insurmountable, the rules allow that kind of definite you cannot go forward, because there's a sort of underlying presumption that there will in fact be another lawyer. Where Travis and John practice, that may not be true. And that creates this scenario, I think, where rural legal practices often struggle to figure out, one, is this a conflict? Two, is the rule, by creating a conflict, in some ways undermining the larger principle that people should have adequate legal representation? In other words, is the rule doing more harm than good? And then, how do you navigate the rule if the rule requires you to accomplish the impossible, meaning bring in lawyers who simply do not exist, find lawyers who don't want cases, and all of this in a criminal practice is running against the clock while people are often sitting in custody, or if they're not in custody, while cases are pending, and where there's one of our only constitutional imperatives, which is to have conflict-free representation.
So as I want to, starting from that as a baseline, what I'd like to talk about, and I guess this is primarily aimed at you, Travis and John, right? Both how your offices, how your jurisdictions have responded to these tensions, the fact that these rules might not always fit, or you might not be able to adhere to them in the way that, others might. And then also how you have sort of, given that every rule leaves room for judgment and discretion, right? How have you sort of personally navigated that tension? So maybe we could start with thinking about how your offices, if there are policies or structures that you all have put in place to try to manage this on a structural level.
Yeah, I guess I start with that one. I think Pam offered a really good and thoughtful summary of what those rules are and what the point of it is. As we mentioned, I was a public defender in this area. I quit the public defender system 17 years ago, but some of those clients still come through. But when you look at the rules in terms of disqualification, is it the same or substantially related? Is it the same case that it was 17 years ago? No, it's not. Those cases are a little long over with and closed. Is it the same person? Yeah, I see the same people over and over again. And the way I deal with it is I ask my staff to deal with those cases, or look at those prosecutions and just not involve me in what's going on. And because my office is large enough with 10 lawyers, 20 people in the office, I can transfer those duties to the supervising attorneys and say, okay, just don't talk to me about this case, and I will stay away from it, and we won't. That's the way we resolve it. But if it really was that there is imputed conflict to the office, that it would be unmanageable because it's too many people for us to deal with. And where it is a problem where there's something that, someone that the majority of the offices has contact with, or it looks like a conflict, because I'm as concerned about the appearance of conflict as I am about the actual legal conflicts. Then what we would normally do, we practice in a judicial district where there's 11 counties, and it's a fair number of areas, but we're the second largest county in the district. So we tend to find someone from a neighboring county or 2 counties away and ask that office to review the file and make the determination, make the charging determination, and appear on our behalf as a special assistant county attorney to prosecute the case, so that we're not involved in those real conflict cases, or where there is a significant enough appearance of a conflict that we just think it's better not to be involved. For example, cases involving our police officers, or our we had a correctional officer who assaulted someone in the jail, and we sent that off to another county, first for investigation and then for prosecution, just to avoid our being involved in that case, and making sure that there was there wasn't that claim of conflict of interest on our part.
If I could just ask a quick follow-up, what do you do in a situation where, let's say, a defendant is challenging a prior conviction and you were the lawyer on that case, given the size and dynamics of the office?
Yeah, that hasn't happened yet. And I think all of my clients would be long out of prison after 17 years. But um, if that did happen, I think I would probably do the same thing. I would ask one of my neighboring county attorneys to review it and deal with it if we thought it was enough of a conflict. But luckily that hasn't happened. I've been here for 7 years, so even by the time I was elected, I'd left the public defender system 10 years earlier. So
Thanks. Travis, do you want to chime in?
Sure, thank you. And the way we've handled it is in North Dakota, at least, again, we're the state agency that oversees the delivery of indigent defense services. And we've developed a hybrid model, and really we're still kind of, I like to say, in our infancy, because the agency was only created in 2005. So we're still actively navigating these things as to how this all looks. But in 2005, the way the agency was set up is with the central administrative office that handles the administrative functions, and then offices that serve as their own separate law firms. So to handle some of the conflict issues, and we have established some attorney performance standards that we expect our attorneys to adhere to, such as not taking a case unless they have sufficient time to devote to the case, and then also not taking a case if there is a conflict. And then also we've established policies that prohibit people from representing two persons in the same transaction or same crime. So really we kind of go a little bit further even than the model rules with our performance standards. So what we've done is we built this hybrid structure where we have not only our full-time in-house employee public defenders, we also have private attorneys who serve as independent contractors who handle a set series of cases. And then we also have attorneys that serve in a different role and really just handle conflicts. Unfortunately, what we're finding now as we get longer and longer into it is that we're having to have people travel vast distances across the state and pulling resources from one area to handle a conflict in another area versus being able to have sufficient lawyers devoted to the practice. So that's one area that we continue to see struggle, but that's how we're attempting to deal with the situation.
I guess I know this is probably expanding on the same, and Pam, feel free to chime in as well, but I'm curious about, I imagine there must be situations where you come up with a solution or an alternative, but there must be situations where practical necessity really butts up against what you feel like you should do, right? Let's say the office is really far away and maybe there's a speedy trial claim and it's not going to be feasible to engage somebody who's going to have to travel several hours. What do you do? And I'm not trying to push you into a situation where you say you violate the rules, but I guess I'm just curious what you do.
Lauren, I'm going to jump in and let Travis and John think for a minute, because since I don't have their jobs, I can talk about situations that I've heard described to me, actually not by John and Travis, where people have sort of decided that the rule was defeating its own purpose. Particularly in low-level cases, I see and hear about lots of instances where people simply act like the conflict doesn't exist or ignore it because they think it's a case that can be resolved in the same day. Someone can roll out of jail that same day. Unless you have to go find a lawyer who doesn't have a conflict, in which case everything's going to slow down. And there's some sense that that's better for the defendant, it's better for the system, everyone moves forward. I'm familiar with cases where people read the rule extremely narrowly. So if I think about John's answer a minute, you were asking about like if someone's challenging a prior. I know of situations where a client in a habitual offender case, right, where they're trying to enhance a sentence based on a prior conviction, and the conflict arises about the validity of the prior conviction. The lawyer on the prior conviction is in the DA's office, where I think judges sometimes will simply, say too attenuated, too long ago, which is too long ago is not the standard under the rules. And I think it's not the same matter in the sense that it's not the current offense, but it's certainly the same sentence that's going to be determined. But my own impression is, and with a deeply unscientific survey that I've done, is that folks really struggle to figure out how to do the right thing when the rules are hobbling them. And I hope that's given John and Travis enough time to think through how they're going to answer that question.
Well, I'll start with the easy answer, which is that the reason that when my fellow county attorneys call and ask me to take a conflict case, I almost always say yes, is so that they'll say yes when I call them. And that's the primary thing is we try to make sure that we're available to assist other offices and handle those cases, or at least review them to determine whether or not prosecution is appropriate. I know we had one case in another county which involved animals, and there's really nothing worse for a prosecution office than to handle the cases involving animals, because people get very exercised about any kind of alleged animal abuse, but the statutes provide for relatively minimal punishment. And I think the out on, this case was also under federal investigation, and because the federal statutes involved potential felony prosecution, our determination was that prosecuting for misdemeanor violations, even though it's in a different county, in a different jurisdiction, ran the risk of interfering with the federal prosecution and the federal regulatory action, and we could actually do more harm than good. And that wasn't entirely satisfying to some of the people who were really interested in the case, but it was what made sense from both a legal standpoint and a conflict standpoint of dealing with, the county attorney who referred it to us determined it was a conflict for his office. So we felt it was appropriate and necessary for us to review it. But it was a case where it's like, well, but if there is federal prosecution available, that seems like that is the better aim and the better resolution of the case than a state misdemeanor prosecution.
Yeah, and I appreciate you very much, Pam, stepping in and breaking that up before I quickly responded to something, being this is going to be recorded and broadcast later. I don't need any sort of inadvertent admission, so I appreciate the time. What I would say is we do pride ourselves in not only providing representation, but providing high quality, effective legal representation. And I think part of that is always trying to be ethical and maintaining those ethical guidelines. So really, we've had amazing bar here in North Dakota that's been willing to step up and help when we've had situations arise, such as I mentioned before with mass arrest type situations. We've had people volunteer to sign on simply just to handle those cases because they knew the bind we were in. So, luckily, we've not been really phrased with that Hobson's choice yet of, what do we do in that situation? But I like to think that we consult the rules quite frequently, and really a question on whether or not an attorney is allowed to withdraw is really the question of the attorney. And we have standards on that as well, that we don't suppose ourselves in their position to make that determination for them whether or not they have a conflict. If they have a conflict, they file the conflict paperwork. We do have a standard that if they've not yet made representation, they can send that to us. Otherwise, they do have to get permission from the court to withdraw. So we do also have that safeguard where the court is taking a look at those as well.
Do you think there's an interesting question from the Q&A that I want to throw in? It relates to something we'll talk about later, but I think it might be interesting to get your take. Or do you think, I guess it goes to why there is this tension, right? Why are the rules written in a way that create this problem? And the person essentially is asking, right, do you think that those who are writing the rules, and those particularly maybe who live in big cities who are often more involved and perhaps in some of these national discussions, do you think that they're just not aware of these issues or how difficult it is to actually accomplish some of these goals in smaller and rural areas? Or why do you think there is this disconnect?
Yeah, I appreciate Fred identifying himself and letting me know that he's watching. But I think that I would say that I don't think that most people understand the practice. I mean, here in Minnesota, where we have a metro area which has more than half the population. Now, I'm just outside of that metro area in a more rural jurisdiction, but I don't think people do understand the windshield time, the drive time that Travis refers to. I don't think people understand it. And assuming that Fred is who I think he is, he's from a jurisdiction where there's 3 county courthouses, and they are a long distance apart. And our county alone is half the area of, almost half the area of Rhode Island. And so there's a large distance to cover. And I don't think people understand the scarcity of resources, the distances that have to be covered, and they don't expect that people have to travel that far. And so I don't think they understand those needs. And I was thinking too about how many law firms have disappeared in the 25 years that I've been out here. That there are not, I live in Northfield, I practice here in Faribault, and I'd say half the law firms have disappeared over those last 25 years. I was part of there were three partners in our firm, and of course we've disbanded, and there isn't anybody that's replaced us. There are other law firms in this area that have closed down in that time, and further out that scarcity of practice is declining even more. So the availability of private practice lawyers is declining at a far more rapid rate than the availability of public practice lawyers, and that the public defenders and county attorneys and city prosecutors may still be available, but there aren't those law firms available to provide those other services as those places disappear because there's no population to support them.
Yeah, I like going after John because he sums it up very nicely. I would 100% agree with him. I mean, I think that's the situation that really existed when these rules were written, is perhaps a lack of understanding of rural areas. Yes. Also, maybe just perhaps a general lack of understanding in how criminal practice works today. And I think, now is probably the time that those need to take a real look at, bringing them into where we're at as a practice. And otherwise we're running, dangerously close to not being able to meet the whole purpose of this, which is to provide that service to the clients or the constitutional mandate. So I would agree with what John said.
Yeah, Lauren, I took a quick look to see if I could find anything the ABA had ever done on this, because, that's kind of the model where all the other rules come from. I think the last ABA opinion that even talked about this issue was from the 1930s. And, those are opinions that were written long before Gideon. So there wasn't the same ethical imperative in terms of honoring constitutional mandates. The other thing I'll say on this topic is I talked to a lot of people in the policy world, some legislators, and their instant response to this problem is, oh, video will solve it. And of course, then we pull up our maps of Texas, for example, and we show them that the same places where there's lawyer scarcity are the same places where there's not enough bandwidth or broadband to use video. So one, it's not physically possible, and two, even if it was, as I think probably every lawyer who's on this webinar can tell you, I think they often don't understand that in a criminal case, video can't fix it all. John's got to earn relationships with his victims, and his staff have to earn those relationships before they can expect people to start, talking about really personal, private matters on video. Travis and his lawyers have to show up and sit and listen and be present with clients before they can expect them to be comfortable on video. And even then, we have situations like we saw in Kansas in the last couple of years, where you have federal defenders on actually both sides of the Kansas and Missouri line who had an agreement with a prison that they would not record attorney-client conversations. They did a lot on calls. They did a lot on video. It turned out they were all being provided to the U.S. Attorney's Office. It's a case called Black. And the federal district court judge had to be involved. And so to those folks who had been thinking, gee, maybe I can solve some of this with telephone and video conferences, those kinds of breaches of confidence, of trust, of faith that the system is going to work, make it very damaging and make it difficult to imagine that technology is the fix here either.
Well, from your first point, Pam, this panel is obviously long overdue, I guess about, 100 years, over to 90 years overdue. So another question, and I guess some things you said I think brought this to the forefront. I'm curious, particularly given, right, we have different representation on this panel alone, whether different parties who are involved in this respond differently. And by that, I mean, prosecutors, defense attorneys, judges, others involved in the sort of administration of justice? Or do they respond differently to these tensions? And do those different actors have particular responsibility given these tensions? And that, that might refer to the parties on either side of the aisle, but it also might refer to the role of judges. For example, Pam raised earlier, right? Judges may be interpreting conflicts in a different manner. So I'm just curious if you all have thoughts on that, either given your particular role or just your experience in this area.
Well, and I can go first and give John a break here of pinch hitting for us. But, I think there is a different response really when you look at not only the rules of professional conduct, but also when you look at the rules for lawyer discipline. One of the things they're always considering is the harm to the client. So as attorneys who are representing clients, I think we necessarily take that a little bit, maybe even further than, and again, I'm not trying to, and John will have a chance to say his piece, but I think maybe a little bit more than our friends across the aisle with the prosecutors, because there really is that, potential harm to the client that these rules are sought to protect. And, we get put in that balancing act, I think, especially given in rural areas, a lot more than maybe prosecutors do, where we also, and I don't think it's unique to North Dakota, but we continue to lose attorneys to prosecutors' offices simply because they have a little bit more pay than we can offer and things of that nature, just the way things are set up. So I think as we continue to see issues like that, I do think that the defense perspective maybe is a little bit more, I don't want to say take it more seriously, that's not the right word, but it's just more personal, I think, to the defense counsel than it is to the prosecutor.
We have now we had a meeting last week with the public defenders and the courts talking about the court's pandemic recovery plan. So because we were effectively shut down for 15, 18 months, we have in our county 349 cases that they now describe as the pandemic backlog. And the court wants to clear those cases, wants to say, okay, here's our plan for clearing those cases. And they were going to bring in a retired judge to handle some of the hearings, and they're going to have another courtroom running with probably misdemeanor jury trials for half the week, so that in our little courthouse with 3 courtrooms, we're going to have 4 judges running court, and we have a pandemic-sized courtroom that we built across the way because our 1932 courthouse doesn't really have enough room to try all these cases at the time. What was the district courtroom in 1932 has been cut into half into 2 district courtrooms, and the jury box is so small the jurors are all on top of each other. So we had to build a courtroom across the street in the government services building where we could have socially distant jurors, where we could have socially distant judges and court staff, and keep the lawyers adequately apart from the witnesses and give everybody their own space. So we will have our felony jury trials in that courtroom and misdemeanor jury trials upstairs in our usual district courtrooms. But the court has issued this statement that we will have people covering the hearings for the lawyers who are in trial or otherwise occupied in contested hearings or in other courtrooms. And that's one thing for my office. That is, I've always asserted my lawyers are not fungible and shouldn't be asked to cover each other's hearings. But sometimes we know we have to do that. But for the public defenders, that is a big problem, because we have 4 or 5 public defenders who practice in our jurisdiction. 1 or 2 of them are full-timers, and 3 would be part-timers. But they have those cases most likely because they are a conflict for another lawyer. And I don't know how possible it is for them to do a conflict check on Wednesday at 1:30 before they go and handle those settlement conferences for the lawyer who's in trial in one of the other courtrooms. And so, you know, I didn't fight about it much, but I think that the public defenders are put in a real bind with this idea that these hearings, all these people are just, you know, these cases are just numbers that we need to push through and work through. But I think that the court system loses sight of the fact there are victims that need to be, their rights need to be respected and reviewed. There are defendants whose rights need to be respected and reviewed, and they shouldn't be meeting a substitute lawyer for the first time at the settlement conference on the Wednesday before the Monday jury trial because their lawyer is tied up in a jury trial in the other courtroom. And just there's a lot of basic fairness questions that I think need to be resolved as we look at not just how do we handle courts generally, but how do we run through this process. And I think back to the earlier question about to the people in the metro area who set the rules understand how things work. And I think that, you know, the discussion was always we would bring in retired judges and bring in public defenders from elsewhere, and it would all be fine, except that, you know, in our county with our 1932 courthouse and our 3 district courtrooms, we just don't have the bandwidth. We don't have the physical plant to have 5 judges. We don't have the public defenders to do it, and we don't have all the other things that we would need to expand any of that stuff. And, you know, for my office, we could try 2 jury trials at a time. I've got the staffing to do it, but how long could we withstand that pace? And I think that's going to be the question as we try to work out this, how do we recover from the backlog? And I think the answer is very different in the metro area than it is out here in rural counties. And I'm not sure that is understood by the people making the determinations.
Lauren, can I jump in with just a couple of observations? One is something that was put in the chat, something that you've worked on a lot, something that we're thinking about a lot at the Deason Center, which is clearly lawyer scarcity is a big piece of the problem. And John's talked about it, Travis has talked about it. It's a problem that's severe, and it's a problem that's getting more severe as time goes along. But there's another piece of it that I'd like to point out, which is that this is not a problem necessarily that lawyers are going to be able to solve on their own. So yes, the folks who are writing these ethics rules probably have very little insight into both the challenges of a really small rural community practice and the particular challenges of criminal practice. Because once you're an expert criminal practitioner, that's the lane you tend to stay in. And if you're a civil lawyer who's dabbling, then, you know, particularly in a serious felony case, woe betide us all. You know, I don't want that. John doesn't want that. No, you know, Travis certainly doesn't want that. Nobody wants to have it happen. But there's a piece of this that I think involves stepping back and having communities maybe do some reflection in terms of problem solving at home about how these things are coming up and where their resources want to go. I'm not going to put John on the spot here, but I do know of places where prosecutors say, I wish I could get my cops to slow down on some of this, you know, low-level stuff. I don't want those cases, and they bring them in, and I want to keep good relationships with them, so I can't just reject everything. But maybe these aren't the way we want to spend our resources in this office. And, you know, going back to sort of thinking about the problem, some piece of it, I suspect, is exactly what John just said. They don't have that the legal system that's been built doesn't have the capacity necessarily to manage the volume of arrests that are coming in. I think that problem is amplified in some places more than others. For example, at the border, I think that's probably a much bigger problem than others because you have the immigration piece and you have the crimmigration piece. But you know, so it seems the way at least I'm thinking about this, and I'd love to hear what anybody else has to say about this, is that there's a rules problem, which is how do you fix or think about or reevaluate what's the right rule to apply? Because it's not a question of how do we get around the rule? It's what should the rule be in order to accomplish our goals? And then there's the question of what are the conversations we need to be having in communities that are struggling with this issue, so that they're not saying, as one prosecutor said to me, I'm so mad at my sheriff I could spit, because the sheriff had brought all these cases that then imposed a burden on the system that the lawyer didn't feel like he could push back against politically, and created a whole series of conflicts that probably didn't have to happen, and certainly didn't have to happen with no notice.
Well, I want to let others respond to that if they want to, but I guess I'll throw one other piece into the puzzle, which is the question of judges, right? We've been talking a lot about the role of lawyers and what lawyers should do when there are conflicts, but that obviously arises for judges too. And there's a question in the Q&A about, right, when should judges recuse themselves? And does that then create another layer of conflicts, especially in counties where there are very few judges? There also might be part-time judges and judges who are playing other roles if you want to complicate things even further. But I'm curious if either of you want to respond to Pam's comments or that question as well.
Sure, I can provide a couple of, I guess, anecdotes, but we do have at least one contractor that works for us that also serves as a municipal judge. So we do have those conversations with him when he signs the contract as to what sort of cases he would be able to take and what sort of cases he would not be able to take. And then we've had to contract specifically for someone to provide for those conflicts. So again, we just try and contract our way around that, being knowledgeable of what is going on. And then, really, North Dakota, again, is pretty good at this, where if a judge does declare a conflict, there is a possibility if there's a different judge within the district, or oftentimes what happens is another judge from a different district will hear that case too. So I don't know that it's been as big of a problem for judges as far as when to declare it. I gave up a long time ago trying to tell judges what to do. It hasn't been real successful for me. So, but again, I think that's the importance of understanding the rules and making that decision within the framework of the rules that we have.
Yeah, and I guess I would agree with Travis that I think we have to rely on the judges to make those determinations of when they're conflicts and when they're not. And that the issue, of course, out here, we have 3 district court judges in our county who normally sit here, but in the other 11 counties, several of them are one-judge counties, and that travel time to another county, I think, can weigh on their determination. But I'm assuming that they're following the rules and conflicting themselves out when it's appropriate, even though that creates an inconvenience for another judge who now needs to travel to that county to handle that case. And that's, it's one of those things that creates pressures. We don't have part-time judges or judges who get to fill other roles anymore, not during the time that I've been practicing. So that's, I guess, one advantage we have over Travis's jurisdiction. But in a one-judge county, I think there's certainly a lot of pressure to handle everything and resolve the cases in your county. But like Travis said, I don't try and presume to tell the judges what to do. And since I don't get out to those single judge counties and normally stay here, I'm not aware of any issues where judges have not conflicted themselves out on a case where it would have been appropriate for them to do that.
Lauren, for whatever it's worth, again, there are really few reported opinions that I've been able to find about rural conflicts. Actually, most of them that I've found have been about judges. There's one from Arkansas in 2016. There's a couple out of California, one from Iowa, and they tend predominantly to deal with the problem of the fact that most judges who are lawyers, and there are lots of lay judges in rural communities, which is another separate conversation, but most judges who are lawyers have come at some point into contact in these small communities with conflicts. And there is this sense that the problem is as intractable, if not more intractable, than it is with lawyers, because often, not always, but often judges have more years of experience behind them than the lawyers do. And, the longer you practice, the more conflicts you accumulate. And so you do find these opinions here and there. There's some out of the 80s and 90s saying that there's an Iowa opinion where the court actually says, due to the geographical composition of the state and the small number of rural counsel, we're going to reject this particular conflict claim. And you see that in rural prosecutor cases, defenders, and judges.
So another question, right, what happens or what recourse is there when things go wrong, right? So we've been talking a lot and we'll talk more about solutions, but I imagine clearly, by no fault of anyone on this panel, but there are instances where things go wrong or where the rules are not adhered to. And what do we do in those situations? What are the alternatives other than disciplinary actions? Or, what else can we do?
Well, I'll take a stab at it, I guess, but one of the things that sometimes we'll see is a result in some post-conviction work, or I guess what some states would call some habeas work, where again, the problem is with that type of work is really that second prong of Strickland and proving that it would have made a difference, I think, which is usually the biggest hurdle for a client who feels like maybe their attorney didn't do or was conflicted at the time they represented him. Again, and then, outside of the disciplinary thing, in a court, I think it's really hard to show and establish that conflict, depending on what the conflict would be, the particular conflict. If it's a personal conflict, that might be pretty hard to prove. If it's a business relation that went bad or existed after the fact, or things of like that might be a little bit easier to prove, but those aren't typically the type of cases that we see. So again, one potential avenue would be the post-conviction or habeas route.
I'll say, Lauren, that part of the problem is some of them, though, I think are unfixable. And what I mean is, my suspicion is that the more serious the case, the more attention people are giving it about the conflict. Right? People are paying a lot more attention to the murder cases, to the long-term state jail felonies, et cetera. And so those, you hope are getting worked on, or if there's a problem and it gets discovered, it's the rarity. For myself, I think what I worry a lot about is the lower level offenses, the misdemeanors and the low level felonies, where the volume may be higher and the attention to detail may be smaller, or there may be a sense of it's just a misdemeanor, or you're just going to get probation, so don't worry about the conflict. In other words, that somehow there's a malleability of the rules depending on the seriousness of the offense. And of course, we all know that, that's an illusion when it comes to both the instant offense and the long-term collateral consequences, both civil and criminal. But that to me is where I really worry, is that some of the damage that gets done is both hidden and often discounted because they're not the rapes and the robberies and the murders.
John, did you want to chime in?
I think that the primary problem is that for the most part, we just have to rely on people to do the right thing, or we have to be willing to be the person to send off the disciplinary complaint. That's always difficult, particularly if it's someone that we deal with on a regular basis or someone that we have a relationship with. But that's the only real option that I can see in terms of dealing with it. I mean, we deal with the after effects of those cases, those that failure to adequately represent somebody, or the claim that someone was not adequately represented, and we have to make that determination. We had a case where the guidelines, Minnesota has a very strict sentencing guidelines scheme program, and so wherever someone is on the guidelines, the sentence is supposed to be in that range, and if it's not, that's an illegal sentence unless the judge has gone through all of the work of doing an appropriate departure. But for the most part, they're in those guidelines. And we had a case where the criminal history score, which is part of what you use to calculate, was calculated wrong. And so the person was sentenced to prison when they shouldn't have been sentenced to prison. So the case came back. And what I do in my office with those cases, I have one lawyer who does those post convictions, someone who's not currently prosecuting. And because I don't want the lawyers to be too defensive about their own work, And he reviewed the case and said, you know what, this is wrong. We need to agree to this sentence. So that's what we did. We just agreed that the sentence was wrong and the person should be released from prison and the court should impose the guideline sentence. And that's what has to happen. And you know, so I think we do our best to provide that separation so that people aren't trying to defend their own work and say, there's no way I made a mistake. And, you know, if the person points out something and we did make a mistake, we try to own up to it and make sure that we're making that situation right.
So one more question, and then we'll turn to Q&A. And I guess this is sort of getting at solutions. Obviously, a lot of what you all do, you've already described things that you do in a sense to try to address this issue. But on a broader level, or thinking about maybe a more structural solution, thinking about the rules and the fact that maybe the way in which they're written are creating this tension, I'm curious what the panel's response would be to the question of, do the rules need to be adapted to better account for this, right? To account for the realities of rural areas, and how might you do that? Or is it just that we need to sort of reform or evolve practices to better adapt to the rules, right? Is it a question of in which direction we go? And if you have suggestions for how you would resolve this tension on that level, I would be curious to hear them.
I can start again. I think the solution is we got to start looking at the problem. You know, and I think, as has been indicated, I don't think we've been paying a whole lot of attention to this until really, you know, I hope this is the start of discussions that leads to some positive change. Now, whether that's a change in practice, which I think is always possible, but I think what's needed is a look at the rules. And I'm never going to be the one that advocates for less protections for a client. I think it's important to have the protections for the client, but I also think that we need to take a look and bring those up to modern practice, bring the rules up to modern practice, and then also, you know, consider that rural perspective and see if we built all sorts of types of screening mechanisms in other situations, and I can't believe that with the creative minds we have working as lawyers across this country and as scholars across this country, that we can't come to some sort of solution. So I think that's where we need to start. If I had the solution, I'd probably be on an island somewhere relaxing right now, but I think we're making a step in the right direction.
Yeah, and I guess sneaking look at the Q&A again, and I think Fred's comment about centralized funding of stuff really makes sense as well. And one of the things I always talk about when I go out in public and talk about the criminal justice system is, let's talk about the criminal justice system, you know, where we are and what we do. And so, like, Minnesota is one of the lowest incarceration rates in the state. They're in the country. And so when we talk about mass incarceration, our incarceration rate is closer to the UK or Norway than it is to Louisiana or Mississippi. And I think Fred's comment about state funding, centralized funding of those systems makes a lot of sense. I mean, Ferguson, the idea that the courts were entirely funded by the people being run through it, that the system actually preys on people in poverty and does its best to keep people in poverty, that's not a system I would care to participate in. I can't. To me, we want to make sure we're ensuring public order, that we're ensuring public safety, and we're having appropriate reactions to people who are violating those standards and making the community less safe. But we certainly don't want to be doing something to make people's lives worse because they've come into contact with the criminal justice system. And the idea that our treatment court went to another state for a mentor visit, and they were talking about how when people come to the treatment court, they have a fee waiver, that the portions of their fees would be waived for doing well in the treatment court, which sounds great, until they said how much they were charging them every month for being in treatment court or for being on probation. And to me, it was not just as an old public defender, but as an old now prosecutor, that we would put such additional burdens on people and expect that that doesn't have a consequence as well. And, our fines are often quite minimal because our judges don't want to impose large fines, and we don't fight about it because the fines that we collect go into the state general fund, and they don't come through here. And we always try to avoid any kind of perception or any kind of change to the concept that we would be prosecuting for profit, because that isn't what we do, and it's not a system that we would want to be in. I would want to be involved in. So I think we need to look at ways to move the system away from an idea where there is a conflict of interest. I mean, we have an old reported case from a nearby county where the justice of the peace or constable was collecting, their entire income, and this was from like the 1920s. Their income was based on the fine revenue that they imposed and collected as a justice of the peace. And that justice of the peace was suing when the county moved him away from that, saying, I don't want to be on a salary. I want to be collecting this. And the Supreme Court decision at the time was, no, it's entirely, they control his compensation. They can change it, and he doesn't have to get compensated based on the fines collected. And that to me is just kind of an indefensible concept of collecting to have your revenue, to your income tied to what the people in the system pay.
And I guess I want to double down on what John just said, which is to say that I think a big piece of this question is what's responsible for the volume that is driving some rural communities into these conflicts. I mean, you will have situations like Travis's where people come to a community and you generate kind of a case volume that creates a problem about co-defendant and co-defendant representation. But, John's exactly right that when, and this was the situation in the Louisiana scenario I was describing, when, sheriffs get to keep the money that they raise through fines and fees, there's a perverse incentive to create a larger criminal legal system, not because that's what you need to keep people safe, but because that's what you need to keep the lights on, whether it's in your office or in someone else's office. And I think that transparency about size and cost is a really important piece of the puzzle in dealing with it. I think that's a home turf question, right? Is how do communities regulate for themselves how much money, how many human resources, how much capital they want to spend in their criminal legal system. I also think that there's some real responsibility in state legislatures to ask, is there a person with experience in rural criminal practice on every committee that is making these criminal legal policy decisions? I'm reminded of an experiment in Arizona where they were doing ignition locks for probationary sentences or for DUIs. And the problem was is that the judges in rural communities couldn't use them because no one could drive 60 miles, 70 miles away every 30 days to have the lock monitored and registered. People's transportation wasn't that good. It was expensive. And so, a well-intentioned reform only spoke to the urban areas in the state, not the rural areas. And I think a lot of the funding incentives work that way. I would resist the idea that we should be changing the duties of loyalty and obligation and confidentiality that are owed. I would suggest that short of a state-funded system, one thing that would help would be a statewide conflict counsel, even at a minimum, that had a responsibility to give impartial advice about the wisdom of waiving your right to conflict-free counsel. I see a lot of people come and tell me, oh, well, we just waived those conflicts. And I say, well, who gives the advice about waiving them? Well, the judge and the lawyer. I'm like, great, that's not a meaningful waiver when the lawyer who is the source of the conflict is advising you about whether you want to waive the conflict. Even that would be a start, a step in the right direction without making an enormous burden on the system. But, Travis, I think, intimated this as well. I think it's time for the regulatory agencies to take a big look at this. And of course, we're talking about it in a criminal context, but as you know, better than probably anybody else on this panel, this is a problem in the civil context as well. And when you talk about rural general practice, and most private practitioners in rural communities are generalists, the conflicts are exponentially increased.
I think you know, some of you touched on this in talking about fines and fees and the role that law enforcement play and making sure that the jurisdiction is able to collect those fines and fees. But there's a question in the Q&A that I think is related, but takes this in a different direction, which is, what is the role of police in these conversations? We've talked a lot about the criminal legal system today, and we've talked a lot about actors, but we haven't spent a lot of time talking about police. So the question is, right, to what extent are they involved in these conversations? So perhaps, I don't know if they're part of these conversations, Travis or John, where you're working, or Pam, with some of the discussions that you've had, and what should their role be in this conversation, or with regard to these types of questions?
I'll go first on this one because I don't have to answer to any local police either, which is, I think there needs to be a realignment of funding priorities. I mean, I'll go back to this. If you're in a scenario where, and there's no reason to believe that this is always the scenario, but if the scenario is that law enforcement is creating the crush, right? There are law enforcement policy decisions that are creating the volume problem, that are creating the multi-defendant conflict problem, that are creating conflicts with a single snitch where all the lawyers in town have represented them, then I think there has to be some responsibility on law enforcement to, at a minimum, be notifying people, hey, this is coming down the pike. I mean, I assume that a prosecutor would love to hear from a law enforcement, I'm going to be making a lot of arrests. There is going to be a big conflict situation. Want to let you know. Don't think that's a huge stretch, although I've never been in law enforcement. But I think, again, transparency about the costs it brings to the system, and taking the advice of folks like Barry Friedman, who think and talk about democratic policing, right, and what it means for communities to tell their police what they want, and you know, kind of in the way John described, being transparent about costs, being transparent about what the goal is, which, you know, and John's talking about public health and public safety. And my guess is that running a court system on fines and fees probably ain't the way to do it. And there is parenthetically evidence, both from Vera and from governing, I think, did a story on this that suggests, at least, that rural communities may be more prone to rely on fines and fees. It's anecdotal. It's not anecdotal. It's documented. It is spotty. So they did a handful of counties in a handful of states, but it was enough to really be alarming. I mean, I think you know, Lauren. One of them was a Georgia. Someplace in Georgia that actually created a whole kind of regulatory scheme that would justify having something policed in order to fund a new septic system, I think it was. You know, and stopping, we have to stop putting rural communities in the position where they think about their criminal justice systems as places where they're forced to make bank. If that's what we're doing, and I'm not saying it happens everywhere, but if that's the way our funding structures are working, then we're doing a disservice to our rural neighbors, and that has to stop.
And I guess I would just reiterate that, you know, our criminal justice agencies and our prosecution, we don't collect any significant fraction of those fees. And I think the statute actually says that when my office prosecutes, all the funds from a fine go to the state general fund. But for cities, for municipalities, then they get some fraction, which at best lightly compensates them for the cost of prosecution and the cost of law enforcement. But it is not a profit center for anyone in our area.
And I think that has to shift the way people think about it. I mean, part of me is wondering whether the reason that John's experience has been in part, sounds largely cooperative on this, is in part because there's not a competition for where the money's going, it sounds like. Lauren, I'm going to.
I was just about to end to wrap up, unless you wanted to add anything else, Pam, since it's at time.
No, I just wanted to remind folks who are out there that, Lauren runs the Center for Access to Justice at Georgia State University, where she thinks and writes an awful lot about access to justice in rural communities, both in the civil and the criminal context. At the Deason Center, we focus predominantly on public defense, prosecutorial charging decisions, and on the operation of STAR legal systems, small tribal and rural legal systems. We have between the two of us, Lauren and I, we have a lot of resources available to folks online. We host periodic events at the Deason Center online. There's a YouTube channel if you're interested in following up on some of the information that we have about ways to improve, to increase the number of lawyers in rural areas. Those resources are in the chat, I think, already, and should be available to folks, or maybe they're in the Q&A, I can't remember. But we really do hope that we'll see you all again at these kinds of events, and that we can continue this engagement. We are always available and interested. I think I can say this on Lauren's behalf, in hearing from you about what you're seeing in your communities, about what we can do in the academy to try and help and support you in improving your practices, particularly in small tribal and rural areas where unfortunately you're getting left behind way too often, and we want to make sure that doesn't happen.
Well, thank you, Pam. Thank you to the Deason Center for hosting this, and thank you to our panelists for taking time away from the important work that you do to join us. We really appreciate you and you sharing your expertise. And just make sure that everyone who is seeking CLE, I'll just highlight in the chat, there's information about how you need to follow up after the event to make sure that you get the credit that you are seeking, at least in Texas, if not elsewhere. So thank you, everyone, and have a good rest of your day.